I'm gonna try and we live?
Not yet.
Okay.
One sec.
I'm gonna try and forward this email to you. I don't know if my
We are live.
Okay, welcome to our Civil Law Subcommittee meeting, March 16th. Sorry, we're starting a little bit late. And I am going to try to really quickly send this to William's laptop, Nicole, or regular? Send to your
Laptop email is thanks.
Ron Watson, Grammar.
And I'll be right back. I gotta go grab something.
Conaway,
Laptop.
Malone.
Here's this.
Who else do I have? Call your names out. I can't see you.
Jones and
Jones.
Watson and Grammar and Crutchfield.
Jones, Crutchfield. And Holly. And who else do I have? Let me just see if there's anything else I'm missing. I think that's it. Okay, great. So let me just send this to you real fast. Let's see if that goes. There's no subject line, it's just the case. It's from me. Okay. All right. Holly, where are we going to start? Do you want to pull a bill up that you want to start with?
Yeah, if you want to do 308, Andrew has a reprint of it without, I mean, it has the bad faith clause in, but we can just talk about it because there were other parts of the SLAPP suit that we amended out.
So I've spoken with Delegate Rosenberg. If we take out the bad faith clause, I mean, if we put the bad faith clause back in, he wants the bill. He does not want the bill out. He does not want to see it pass.
Do you want to bring the bill up though, what we have right now with it also amended?
Sure.
Just so everyone can see it. I can easily amend that clause back out, but I just so we can kind of vote on the amendments that we also put in.
Yes, just okay.
Thank you, Andrew.
There we go.
Okay. So we're going to take the bad faith. You can see in
Paragraph 3.
Paragraph 3, line. We have the bad faith clause put back in. I mean, and we want to. If we're going to pass it, we're taking that out. Here's one of the things I had suggested to Delegate Rosenberg as a way of trying to work on this is if you're seeking attorney's fees, if the defendant is seeking attorney's fees against the plaintiff, that they have to show bad faith. But if they just want to have the case dismissed without seeking attorney's fees, they don't have to have bad faith. They can just have it just in the public interest, which is the way that it was originally drafted. Delegate Rosenberg was not happy with that language, didn't think that was a viable compromise, doesn't understand why, if we got it out last year with the bad faith clause out, why we can't get it out this year. And to be perfectly frank, I have given it more thought. I think some other people have given it more thought. And that's the issue that I have. The last thing I'll say, and then I'll let questions be had, is another amendment that I talked to Delegate Rosenberg about and that he is okay with, is to allow for full discovery at the motion to dismiss stage for being defined as a SLAPP suit, as opposed to just targeted discovery. Okay with that amendment. And that is down, if we go down here and you look,
Delegate Cardin, did you say you sent this to us so we could read it? I can't find it.
now I just sent you the court case that Delegate Rosenberg had. Could you go back up? Or maybe it may be down further. Let's see. Keep going down. Down. Keep going. Okay, here. In line 6, if it appears likely that the targeted discovery, you get rid of targeted. You just say, if it appears likely that discovery will enable the plaintiff to defeat the motion, and that discovery will not be unduly burdensome, the court may order that, and we get rid of targeted, that specified discovery be conducted. So basically, you are allowing for the court to decide that full discovery is appropriate. Those are the two things we discussed. He's okay with the discovery issue. That helps some of my the issues that I've brought up, but it's not full. So let me let questions be asked first, and then I will bring up what we can see if we can get to a resolution. Let's start off with Delegate Crutchfield. Then we'll do Delegate Conaway, then Delegate Williams.
Thank you. I know I got on the call a little bit late, but my real question is, how many other states have taken out or have excluded the bad faith clause in their anti-SLAPP?
That is a great question. Holly, do we have any information on that?
No, I don't have information on that.
Okay, because I would just be really curious, because I bet they still have bad faith in there. You know, so, okay.
Thank you. That's a very good question, and maybe it's something that we can.
I looked through a few states, and I wasn't in the states that had the strongest anti-SLAPP laws. There was nothing that said bad faith.
But we want to know, are we talking about 3 states? Are we talking about 25 states? We don't know.
Yeah, I can try and get that information.
Okay. Great. Delegate Conaway.
Thank you, Mr. Chairman. I think that the number one issue is if we take out the bad faith, that the good delegate doesn't want the bill. And I don't think that we should supersede his request for not having the bill if you take out bad faith.
He made it clear that he doesn't want a bill without the striking of the bad faith. He's made it clear about that. But
So he wants the bad, he wants the bad faith in, or he wants
out. He wants it out.
He wants it out.
Yes.
So then we should, if we're not going to take it out, then we shouldn't move the bill, I don't think.
I agree with you. I agree. That's basically, we don't want to, if he doesn't want the bill at all because it doesn't look the way he wants it, then we can just hold the bill. That's true.
Thank you very much.
Okay. Delegate Williams, did you have a question, or are you done? You know?
Delegate Crutchfield asked my question, so.
Delegate Grammer.
Is Rebecca Snyder here from the Press Association? Can we bring her in if possible?
Is she in the waiting room?
No, I can try to get her if Delegate Cardin wants.
You feel free to get her if you want.
I meant to talk to her, but I didn't have a chance.
So why don't we pause this? I'll see if I can get her on, and we can move to another one while I work on that. And she might have some answers with regards to Delegate Crutchfield's question.
Thank you.
All right. You can put your hand down, Delegate Grammer, if you want. All right. Why don't we move on to, Holly, you need to be able to focus. So I don't know if you want to, or is there a particular bill that we can deal with it?
Yep, let's try to talk about 405 a little bit. I think that one needs to be addressed. That's the joint one with Ways and Means that deals with attorney's fees and expert witness fees. We talked about it a little earlier.
So we've talked about this bill.
I'm sorry, what number?
This is 405. 405 is a bill that allows, or it requires the court to provide attorney's fees and expert witness fees to plaintiffs if, who are guardians of a child, if they win a suit against the school system for special ed requests of services. This has been a very tough bill. It's come out of Ways and Means twice. It's jointly assigned to us in Ways and Means. It did not come out of our Civil Law Subcommittee last year. One of the issues that we faced was the question of cost and whether cost should even be a consideration based on the needs for these children. I sent you all, you should have gotten it, at least I sent it to Holly, and hopefully we got it to everybody, a list of all the cases and how and what their outcomes were over the last like 5 years. Does everybody have that?
If not, I can
I don't
forward
think
that
I
out.
If I can get that to my laptop also, I don't know what email that went to.
There. So let's see. I know that I sent it to you, Holly, right?
Yep, I have it. I'll forward it along.
Oh, great. Okay. So we have one major issue, and then we have to just discuss the policy. The first major issue is that when it comes to fees for expert witnesses, this is something that we were going to look into. I think that Delegate Crutchfield said she might. The truth is that we have information from 2 jurisdictions, and I have a feeling that if it got out to other jurisdictions, they would equally show their concern with this. That this is already settled law in the Supreme Court that you cannot assess expert witness fees onto, it's a direct on-point issue. It was authored by Sam Alito, unfortunately, because I'm not a huge Alito fan, but that it's directly on point that you can't assess it if it's not included in the law, and it's not included in the law, and therefore you can't assess it. So I think that regardless of what we do with this, we cannot include the expert witness fees. Is there anybody who wants to go further with that? Holly, should I forward this email to everybody?
So it's you feel free to forward it along. It includes 2 pieces of testimony that I looked into, and it just lists the Supreme Court case. And I think with that precedent, it might be tricky. But forward it along to everybody, and then I'm forwarding right now the data that we received, and we can go from there.
All right, let me do that. Sorry, so I'm trying to.
And I just heard from Rebecca, Andrew, she will be in the waiting room shortly. Just a heads up.
All right, this is going to take me a second to do. I'm going to do this again. See, unfortunately, guys, my Outlook is not working. So I can't forward that to you because I don't.
That's all right. I'm sending it to everybody right now.
Okay, thanks. So what does everybody think? This is again, I mean, I feel for both sides. What does everybody think about? Right now, the way I believe the law reads is that the court may grant attorney's fees to the prevailing party. And the way that this law, if we pass this bill, if we struck the language regarding expert witness fees and we just kept in the law about attorney's fees, what we would do is we would say the court shall award attorney's fees to the prevailing party only if the prevailing party is the guardian of the child. Holly, does it also say that does it keep in that you may award attorney's fees if it's the prevailing party is the school system?
I'm looking at it right now. I just sent everybody the data. So if you want to take just a quick second, you should be receiving it. It's quite a few things. Sorry, we didn't have this to you before, but hold on, Delegate. I'm pulling that up right now. Did everybody receive it? You should have 2 emails, one with the Supreme Court case and some testimony, and then you have a larger document with Excel sheets and some data that we received.
I did not get the Excel sheet.
Was that sent just to our delegate email, Holly, or?
It was sent to the same email that you would have gotten your Zoom link. And Delegate Grammar, apologize, not a, it's 3 Word documents and a PDF or PowerPoint presentation, not an Excel sheet.
I
Sorry.
just got it. Thank you. I do have a question, Mr. Chair.
Yes, Delegate Grammar.
So can someone who practices comment on the principle here of awarding attorney's fees? Because I can name a ton of situations where it would probably be legitimate to award attorney's fees. What if the state does something and it's a damage to your property, or there's an environmental issue, or any kind of civil damage where the opposing party has been found like negligent? I mean, what's the principle here? Because I understand the premise of the issue, but if we award attorney's fees here, why not just award them in any civil issue?
Well, right now, I'm trying to pull up I believe, so okay. According to the bill, it says that the court may award reasonable attorney's fees to the parent or guardian of a child with a disability. Subject to paragraph 3 of the subsection, attorney's fees may not be awarded and related costs may not be reimbursed for services performed after the date a written offer of settlement is made. Right. So this is just a may, it's not a shall.
And I get that, and I'm open to opinions here, but why not may all the time? I mean, why not make it contingent on every civil case?
So Holly, isn't it my understanding that attorney's fees are already able to be awarded in this case?
Yes, I mean, usually it's a may for the prevailing party. I mean, I don't know if another member wants to speak to this, but that is the case. The issue here is the expert witness fees, which is the same issue that essentially that's why the bill didn't make it last year, and that's why you have that case in front of you. Expert witness fees are not traditionally awarded, and this bill is also the prevailing party has to be the parent in this situation. So that also just things to point out. But there is a may, but it's
Only for the prevailing part, only if the prevailing party is the parent, not if it's the state or the county.
And that's why you see the opposition from the school boards. So just to point that out.
So it's unconstitutional to award expert fees, and it's already the case that we may award attorney's fees. Am I understanding that properly?
That is my understanding.
All right, Mr. Chair, I love you and I love the sponsor of the bill. I think you need to give us some leadership here.
I think maybe we'll, why don't I talk to Delegate Lopez and see if she wants, what she wants to do with this?
I appreciate that, and I think we all do, Mr. Chair.
Is there anybody else who has a strong opinion on this bill that wants to push it for a vote at this moment? Okay.
If you push it for a vote now, I think I'm voting unfavorable because I think we're passing unconstitutional.
I would agree with that. Okay. Why don't we bring back 308? Oh, yes, Delegate Williams. You're on mute.
You muted.
Yeah, if we could pass it to read this, that would be great. It looks like there was also a dissent by Justice Ginsburg, according to the summary that we were received. So I'd like to read both, not just the opinion, but also the dissent as well.
Absolutely. And you can be assured that that dissent was well written and very, very much important for us as well. Okay. Delegate Grammer, you had a question for Rebecca Snyder regarding 308. We're going to return back to 308.
Rebecca, are you here?
I am here. Thanks for
You
grabbing
didn't know
me.
we were hearing this bill in subcommittee right now? Come on.
Well, I thought it was at 6 p.m. So my apologies.
blame the
there.
That's true. We did change the time. We changed the time up.
We did change the time.
Okay, so I wanted to ask you to comment on this bill that I can't make any promises on this one, but I think what's a big part of what's in question here is the bad faith, if you want to articulate about the bill.
So bad faith is an extraordinarily subjective requirement, and it's such a high standard that it makes it well nigh impossible to meet. So I think one of the most recent cases in point was the dispute between Clipper Mill residents in that condo and the developer, where that was obviously a slap suit that he brought that suit just to intimidate residents. And the judge in that ruling, and I can pull up the write-up from that, what I believe I've already sent it to you all, but specifically the judge said that the bad faith standard is so high that he could not say, yes, this is a slap suit because of that. And so you have all these people, and they're usually, press is a piece of it, but you're usually talking about regular people, citizens that are standing up for something that they want to say about their community. A lot of times in developer situations, and those people are left twisting in the wind, defending themselves against specious lawsuits that really just shouldn't be out there. And bad faith basically takes all the power out of an anti-SLAPP statute. Maryland's anti-SLAPP statute is so meaningless right now. It doesn't have mandatory fee shifting, which would really mean, okay, if you think there's a suit here, you can run it, but if you're just filing to file and to grind someone down, if you're going to get hit with attorney's fees, you have to think twice about what you're doing. So I think those two pieces of the bill are critically important, and bad faith is, we have to get the bad faith language out of there.
So I think the general concern was if someone had a legitimate suit, the student in DC with the Indian guy in his face comes to mind, and then if we take this out, you have a lot of legitimate suits that might just get thrown out.
I don't think so. I really don't, because that's where the discretion of the judge comes into place. They can order as much or as little discovery as they choose to do so. This is not a situation where I can say, oh, I'm being slapped, and everything stops and I always get my way. Like, there's a process, there's a hearing, there's a judge that's saying, no, Rebecca, you're off the rails here. This is a legitimate piece. But if the bad faith requirement is in there, it just makes the bar so high that it's not, you really aren't getting any protections under the law.
Malone, is it you have a question? Is there something I'm missing here?
No, I think you got it. I had raised my hand earlier basically to sort of talk about the American system versus the European system regarding attorney's fees, and how the American system is not that the loser pays. Just that was the 2 cents I was going to throw in.
So you support this bill, or is there something else that I'm missing?
I would want to keep the higher standard in. So I don't support it as Delegate Rosenberg wants it presented.
So when you say that the loser doesn't pay in the American system, you don't get to get, basically, if the defendant gets the motion dismissed, wins the motion to dismiss, Rebecca is saying they want to be able to recover fees, right? Attorney's fees.
Mhm.
If
Right.
the plaintiff wins the motion, then the plaintiff should get the fees from the defendant. You're saying that you think that's the case.
Absolutely.
All right.
And that's
But-
how this bill is written. If it's a mandatory fee shifting. And so it's whoever prevails, the loser pays those fees. And so it means that if I'm a reporter or a publication, then I would have to pay those fees if it's found against me. If it's the plaintiff that loses, they have to pay the fees. And so if I'm that developer that's just speciously throwing out suits, then there has to be some economic consequence to that, or why would I stop?
Gotcha.
Delegate Williams, then Delegate Conway.
Yeah, I was just going to ask the question we asked earlier just to see if Rebecca may know the answer to save us some time. Rebecca, do you know how many states across the country have SLAPP statutes that does not include the bad faith element?
Oh, I think we're the only one that has the bad faith element. I mean, like, that's what makes Maryland statute, laughable, I guess, there are not teeth here. I will dig and double check, but there's no one that I'm aware of that has a bad faith piece.
Okay. And how many other states have similar laws, just generally then? I apologize, I don't have my floor thing in front of me with the testimony from the hearing.
I don't think we put that in our testimony anyway. Most states have a statute, and most states, so like the gold standard now in SLAPP statutes is bad faith. Doesn't even enter into it because nobody does bad faith. And the gold standard is the fee shifting.
And I can just add, Delegate Williams, I was just Googling earlier just to see if I could find, it was 29 states, I think, that have some form of SLAPP suits right now. Varying forms, but 29.
And yes, and so actually I'm going to ask.
And there are 2 other states with bad faith clauses.
Okay, and I don't think any of them are being held up as great standards of an anti-SLAPP statute.
Delegate Conway has a question.
Sure.
Thank you, Mr. Chairman. I was wondering, is there any monetary limit or cap on these SLAPP suits?
This bill does not anticipate that, but I also have to just kind of reinforce that this is not happening in a vacuum or, just on a street fight. Like, a judge is there to say, this is what's happening. And the judge can figure out, if they want to cap it. I would think if you're talking about an anti-SLAPP, and let's just walk through this process, there's a limited discovery. So the judge can say, yes, this is a SLAPP suit, or no, it's not. If it is a SLAPP suit, it hasn't gone on for years and years and years. And so the attorney's fees couldn't be in the millions of dollars, but it does take, every time you defend yourself against a suit such as this, I've heard that it's, minimum like $7,000 to $10,000. And I don't know about your pocketbook, but mine would never be able to handle that. And so that is really, from a citizen level, these suits silence people who are just trying to talk about their communities. They also can have a chilling effect on free speech and reporters, but the majority of these issues really are, companies against individuals.
Thank you.
All right, I've got one more question. Delegate Malone, do you have another question?
No, I'm sorry. I'll get my hand down.
Delegate Grammer, you have another question?
Yeah. Do you think the suit, the Nicholas Sandmann suit against the Washington Post, do you think that was a slap suit? Would you define
I don't
that?
believe.
Sorry, go ahead.
I don't believe that was. I don't think that was classified as a slap suit, because they reported as the events came about. So it wasn't that they picked that boy out of a crowd and said, "We're going to grind you." They were reporting on that event in total. So I don't, and I know it went to litigation, but I don't think it was a slap suit.
Yeah, I think you have to think about it in the reverse. I think he sued them, and they actually got it thrown out, if I'm not mistaken, as a slap suit, and it was subsequently reinstated. And I think that's kind of the concern. And I could be wrong in the details there, but I'm pretty sure that's how it panned out. And I think that's generally the concern, is you get someone who's, who suffers consequences of reporting. And, if you pass a law like this, I'm not sure that survives.
Well, and so actually, Delegate Grammer, I just did, I'm working on two different screens here. And so I did look that up quickly. And that was, the Post never claimed that to be a slap suit. So they didn't challenge it under those grounds. That's not, we're soon very beyond my technical expertise as a non-attorney. But they objected for, they were, it was, hang on for just a second. I want to make sure I've gotten this right. Come again. So I don't think that they said it was a slap suit, and it was thrown out for other reasons, is my understanding. Yes.
But it could be, if you put a law in place like this, they very well could have said, this is egregious, this is punitive, you're just looking to get at us, this is a slap suit, and move to dismiss.
So it was thrown out, and so full disclosure, I have the attorney from the Washington Post on the other line who's telling me that it was thrown out because the judge found that the statements were non-actionable under normal libel law. So you do have libel law coming into play here. And he says that 30 of the 33 statements were thrown out. So it wasn't, I think it's two different pieces, two different things there.
Okay. All right, I appreciate it. Thank you.
Sure. Delegate Cardin, if I could interrupt, you're on mute.
You weren't interrupting because I was on mute. All right. Just very quickly, in the Clipper Mill case that you sent us, didn't the defendant wind up winning that case?
They did, but I don't believe it was on a slap piece. Let me look that up and see, because that went back and forth.
You're saying that the judge had a hard time finding. You're saying on the one hand, the judge has discretion to award or not award attorney's fees, or to figure out how much discovery, what discovery. The judge is really on top of this and stays on top. But in the other sense, the judge doesn't have the discretion to really say, yeah, this was bad faith or this wasn't bad faith. Is that because the term of art bad faith is just too high of a bar for any judge to have discretion? Is that the idea?
No, I feel like the judge sort of judges are skilled in the nuance of things. However, I think it goes on so much longer than it needs to, and you're only getting to the most egregious places. If it's not casting its net wide enough to do you much good, or in only very narrow places, the law should be changed. And so what we're really arguing for is kind of a standardization of slap law. You've got um, 28 out of 30 or 27 out of 30 states with no bad faith requirement, and things are working quite well. And I feel like when you have this in Clipper Mill, it was just the judge himself said, the bad faith requirement is a difficulty here. And so I feel
let me give you one quick scenario.
yes.
Politician has a person in the community or editor at the newspaper that just wants to mess with them, wants to hurt them. So they go and they find on social media a claim, an allegation, a nasty allegation about that politician, and they say, there's an allegation that this politician is is stealing money from the fund for disabled war veterans. Even though they did no research, they didn't want to do research because they would have found out that it was a debunked allegation, but there was no bad faith in theory because, or if you didn't have I shouldn't say it, there was bad faith, but if you didn't have the bad faith clause, there would be no way to stop that person from being able to report that.
I feel like you have a really good libel law out there. Where if it is an undocumented
Against a politician, against a public figure? No way. You can lie about a public figure and you don't have a libel or defamation suit. You can't, I mean, that's impossible.
But it's not if there's no sourcing there, if there's no if you're just pulling something off of the social media site, you're not doing any documentation, you're not researching it, that would never, you don't need the bad faith requirement for that because that's so egregious. Any judge tosses that immediately to say, hey, that's a problem with the reporting. That's not, I don't think you need that.
I'm the politician. I'm filing a lawsuit against the firm or the newspaper for damages to my ability, my reputation, and my ability to, you've now destroyed my entire life because I now can't get a job because everybody thinks I'm a cheat, right?
Right. So lying is actual malice. I mean, like this is the Bobby Zirkin argument that we've heard for a long, long time. And
there was no lying there. There was no lying. Oh, look, I found this allegations. I put them up. You're not lying. You're not saying anything wrong. I'm putting that out there only because I had a newspaper editor who had something against me years ago and would just put things out that clearly were not well researched, but they were not, they were, in my opinion, they were in bad faith, but they weren't lying. They weren't saying anything untrue. It was out there that John Carden was responsible for 6 murders in Baltimore City. That was the allegation. John Carden was responsible. Didn't say I murdered 6 people. It said I was responsible for murders in Baltimore City. And that editor repeated that in every single news article that they put out. Now,
and you didn't take legal action against that because that does.
There was nothing. It was an allegation that was put out there. There was never any proof that it was or wasn't. What am I to do? I'm a public figure. I don't have any rights to claim defamation.
But I think under actual malice, and this is, not really my area of expertise, reckless disregard for the truth, which is not lying, is considered malice. And so if your concern is as a politician, as a public figure, you don't have enough protections, so you don't want any of the other citizens affected by these suits to have those protections, then that's a choice, I guess.
But
I don't think bad faith helps you here.
But I don't think that would be considered malice in any way, shape, or form. I think it would be considered, unfortunate that person kept saying those things, which were wrong, but they weren't malice, and they were in bad faith. That's the way I see it. So
And so we might have a difference of opinion here. I mean, I feel like your life is going well now. You
Oh, no,
haven't
I'm-
been harmed by that editor
Fair
from
enough.
years ago saying that you're responsible for 6 deaths. I mean, maybe I'm off base here and you're putting a good smile on a sad life, but is it really an issue here for you?
Right. Well, I'm bringing it up as an example. I brought it up with my subcommittee as an example earlier. So, okay.
All right.
But it actually did happen. And I'm just trying to
I'm not discounting your lived experience for sure, but I think your quarrel is with the New York Times versus Sullivan rather than the anti-SLAPP law.
Yeah. Okay. Fair enough. All right, Delegate Williams. And then
I was just going to ask, Mr. Chair, do we need to vote on the amendments or could I just move favorable on the bill?
well, we can, Holly, do we have the bill? So what I'd like to do is have at least take out the targeted discovery and allow the judge to have discovery if the judge chooses to. That would be the bare minimum. Can I have a motion on that amendment to take out the?
Move that we remove targeted from the bill.
And is there a second? Okay. All those in favor of the amendment, raise your hands. Okay. 1, 2, 3, 4, 5, 6. Okay. Any opposed? Anybody want to be marked as opposed, even though these aren't recorded? Okay. The bill so that would, Holly, that would the only change from the original text of the bill will be the.
So Delegate Cardin, the original text of the bill as it was,
Originally entered.
okay, not as amended by the subcommittee previously.
Right, we take
Okay.
out the bad faith clause, and there's a motion favorable. Is there a second? There may not be a second.
Second,
Who seconded?
I did. Can I second it?
No, you can't second it. You made the motion.
Oh, you're doing my motion earlier. Okay, so never mind the maker of the motion.
You made the
Got it.
motion. If there's no second, then we can.
Second.
Oh, Delegate Jones seconds it. Okay. All those in favor of the bill as amended, please raise your hand.
Mr. Chair, could you
Yes.
just go back over what the amendments are just with the bill now?
Sure, absolutely.
Sorry.
Discussion. Absolutely. So the bill is as originally dropped. The bill will takes out the bad faith clause. So this is not the bill. Andrew, I don't want to put this.
Oh.
This is not the bill. The bill is the original bill as entered. So if you can pull, Andrew, is it possible to pull up 308 as the original?
Yeah, is that not what I had?
No, bring it up on the General Assembly website, Andrew, without the amendments.
Yes, Delegate Conway, while we're waiting.
So what we're voting on is to take the bad faith clause out.
Take it back out and have it as it was originally drafted.
Right, but with the bad faith clause out, the sponsor of the bill does not want this bill. Is that correct?
Yeah, that is incorrect. The sponsor wants the bad faith clause out.
Out.
We had amended it back in.
You amended it back. Okay, all right.
Sponsor had said that if we can't get that out, that he wants to withdraw the bill.
All right, thank you.
All right, so here's the bill as originally brought to us. So if you look at paragraph 2, line 12, brought against a person based on an act or a statement of the person that was done or made in furtherance of the person's right to petition or free speech under the United States Constitution or the Maryland Constitution or Declaration of Rights in connection with a public issue or an issue of public interest, including a written and oral statement made. And then in the qualifications for where, before a legislative body, et cetera, et cetera, et cetera. A place open to the public, a government official, an individual. And a SLAPP suit is not done when it has to deal with financial implications to benefit or harm either the plaintiff or the defendant. Okay. So that says original, and then the amendment takes out targeted discovery and just says the court can grant discovery. So it gives the court more direction to allow full discovery if the court so chooses. Okay. There's a motion and a second. Any other? Delegate Williams, do you have a comment or you just have your hand up? All right. Delegate Grammer, last
Yeah, just want to make a brief comment. I'm really close on this one. I want to support it, but I have some more questions. I'm trying to get there, but I recognize there's a motion and a second. So I'm a no for right now if we're going to call this, but I just wanted to put that on for record.
Okay. Very good. Appreciate that. All right, Andrew, you can take off the bill. Is there any other questions? Delegate Crutchfield, do you remember now what the bill does? Okay.
I just want to, yeah, I do. And I just want to make sure. So this, in its current form, is substantially the same bill that was passed out last session, except for, okay.
That's correct. And then we allow for, I mean, targeted discovery and full discovery is really the same thing. It's whatever the judge's discretion is.
Okay.
All those in and by the way, I don't know if we have, I did not count votes. And you know me, I am not 100% on this bill as well. So let's just see what happens. This is going to be very interesting. All those in favor of the legislation as amended, raise your hand. 1, 2, 3, 4. All those opposed, raise your hand. 1, 2, 3, 4. Holly, rules. It's a bill, not an amendment.
It's a tie. I mean, this will be a chair question. I'm not sure with a tie. Usually I think the chair takes it, but in a subcommittee, I'm not.
Right. If the bill fails, I'm going to ask to hold it. And we can get some further explanation. Maybe Delegate Grammer is going to swing one way or the other.
Are there other
right,
questions that you have for me? I mean, that I can ferret out answers to?
I think that
I
your
have
help
Snell and I can hunt you down, but we do have other bills. So
Absolutely.
Thank you very much, Rebecca. I really appreciate it.
Thank you
very much for that long discussion about that bill.
I'm sorry.
And if it passes, Holly. We'll find out from the chair.
Rebecca, really quick, can you send us those cases, please? That you referenced?
Absolutely.
Thank you.
I'll do that. Thanks.
All right. Very good. All right. Let's go. What we have, we did 405, we did 308. Those are the two most difficult ones, I think. What else do we have?
23 and 766.
So 23, I can just give an update. We are asking for an AG letter of advice. Spoke to Delegate Stein and Patrick. We've been emailing. So there was a letter of advice for 2018 on House Bill 23 that just dealt with the MVA in the process. And they're just asking for an updated letter. We're going to go from there. So let's hold off on 23 and hopefully we can get one ASAP to move forward on that bill.
And the reason is because the Department of Corrections wouldn't accept an AG letter saying this was okay based on MVA. They wanted to see it for themselves, for their department.
Mm-hmm.
All right. So we're going to hold off on 23, and then we have 766.
Yes.
Okay. Let me just get my notes up. Okay. So 766. I got some information from Delegate Terrassa, of course, like 10 minutes ago, not an hour or 2 hours ago, unfortunately. Proposed language. The register, here's some proposed language, and this is for the benefit of Delegate Jones, perhaps Delegate Conaway. You might want to listen to this. The register shall not assess or collect the probate fee if, 1, prior to the ratification of the 13th Amendment to the Constitution of the United States of America, the decedent was enslaved, or 2, prior to or after the ratification of the 13th Amendment to the Constitution of the United States, the decedent was engaged in indentured servitude, or 3, prior to or after the ratification of the 13th Amendment of the Constitution of the United States, the decedent's primary vocation was sharecropping, or 4, the decedent is a surviving spouse, domestic partner, child, or stepchild of a decedent described in subsections 1 through 3 above, and 5, the personal representative of an interested person or an attorney files with the register an affidavit that contains 1, the full name, 2, the date of the decedent, full name of the decedent, the date of birth of the decedent, if known, the date of death of the decedent, the statement that describes the enslavement, indenture, or vocation of the decedent, and if the decedent was an individual identified in subsection 4 of the section, a statement that the information provided on the affidavit is true and correct to the best knowledge of the personal representative of the interested party or attorney, the signature of the personal representative, interested party, or attorney. That's basically to try and deal with the situation. Here's the long and the short. I haven't gotten the okay to create a fiscal note on this legislation. And I'm sure we could do it and then let it die somewhere else. Or we can do what I believe is the appropriate thing and just increase the fees marginally, not significantly, but marginally on the 1, 2, or 3 estates a year across the entire state of Maryland that have an estate go through probate. I am also happy to not do that for, and I thought about this, is I had originally said between 750 and $1 million was one increase. Just go for any estate that's $1 million or greater, just have it be an increase of a couple $1,000s. It's not significant for those estates. It won't have any bearing on people's decisions as to whether to probate in the state of Maryland or not. It's just going to equalize the fiscal note so that we break even on the bill. I'm happy to do it. I'm happy to just kill the bill. So
That's what the
anybody
bill
have any
did.
comments? Yes, Delegate Jones. I'm sorry. Delegate Jones.
It's okay. Yes. So, Delegate Terrassa and I did have a chance to talk, and they did send me that language. I think the first email, I had some concerns. I'm still a little concerned. I like the addition, certainly, because as I mentioned before, I think these kinds of fees, even though it seems like it's just 1 or 2 estates a year, again, as I mentioned the last subcommittee hearing when we addressed this fees like this are how African-American families in this state who have been holding on to land since slavery ended, and it's generational land, that this is part of how they lose it. And so I do like that this language has been proposed. I did have concerns that will a statement be enough? Will they be required to somehow provide some sort of other proof that, hey, in my family's case, would they be required to provide some sort of additional information other than just a verbal statement that says, the original estate holder was a sharecropper? Is this language sufficient enough to protect them? My question.
I believe it is. I believe the language is pretty clear. And I believe that if we create the discretion for the judge and the assessment is made, given this language, I think it's going to be difficult for a judge to ignore an affidavit stating that. That's my opinion. But I mean,
you're saying discretion of the judge, and in every county, that may not work to the benefit of African-American families.
Right. Well,
I hate to say that,
but the way I read this statement, if you have this affidavit, you can't be assessed the fee. No, that's the way I read this. But if you don't have this statement, you have something other than this. I think that this language would inform the judge that the intent is not to assess the fee on people of, of this, of having this background. So that would be how I would say it. But let's answer some questions and then see where we go.
Sure. I just would like to say, I'm sorry, I would just like to say that having just received the language sort of, within the last 30 minutes or so, I am not comfortable. I feel like I need more time to review that before I could cast a vote today and say, like, I'm in full agreement with this. I just want a little bit more time to review it.
Fair enough. Okay. All right, Delegate Crutchfield.
So I share some of the same sentiments as Delegate Jones. My family's owned property in Rockville, Maryland for over 150 years. So, and we are the descendants of the slaves who actually were on the plantation where the property was purchased from. So I do understand and share those sentiments. But one of the things also I want us to think about is that it does not sound like we have received information from all the various jurisdictions regarding the increase. And I just kind of feel like this may be something that we may want to have the sponsor to consider, just forming a work group over the summer or, doing a little bit more research on this. Because I agree, I'm not quite ready to cast my vote for this legislation.
Delegate Conaway.
Thank you, Mr. Chairman. I'm in agreement with Delegate Crutchfield and Delegate Jones, and I'm not really ready to cast my vote either, but I would like to know how many generations down are we talking about? I mean, I thought you said maybe grandchild or something.
So this basically says descendants of, what the language here that was proposed is a descendant that was engaged in either slavery and indentured servitude. Primary vocation was sharecropping. So it doesn't matter how many generations, it just matters that the land has been passed down from that.
I thought you read more. You sure you read it all?
The decedent is the surviving spouse, domestic partner, child, or stepchild of a decedent described in subsections above. So it doesn't matter how many generations, it would go from generation to generation.
Okay, thank you.
All right, so I then, given kind of where everybody is on this, I'm gonna talk to our chairman about the bill as amended and see if he has any interest in getting it to go out, which I don't think offends anybody, or whether we should just hold the bill until next year or ask Delegate Terrassa if she wants to amend it to just be a work group, which is not a bad idea.
Mr. Chairman, I don't think that's respectfully, I don't think that's an accurate statement, because if the chairman decides that he thinks that the bill should go out, you've had at least 3 of us that said we need more time to review this bill.
Right. Well, the bill is the bill is amended right now. The only thing that the bill is amended right now does is it just waives the fee for anybody with an estate under, I think, $250,000 or maybe.
So are you saying everybody's in agreement with that?
Everybody's in agreement with that. In fact, everybody voted for that amendment. Or not everybody voted for it, but it got a majority of the votes.
Thank you.
I shouldn't say everybody voted for it. So, okay. Thank you. Holly, do we have any other bills? Are we done?
No, we're done. So, yeah, we are finished until tomorrow. No back room, and we'll see you all after floor at some point tomorrow.
All right. So there's a chance that we're gonna have to revisit 308.
Yeah, we have Delegate Carter, we have a standing meeting tomorrow. So hopefully, Dylan, we'll send out an updated list to you, and hopefully we'll have some answers on those bills that you wanted a response to.
Right. We have a few bills that we might revisit, and we have one bill that may come in, House Bill 213. I am not sure whether it's coming to us or not, but maybe it will. I hope. So we'll see. All right. Very good. That concludes our subcommittee meeting for today.
Thanks, everybody.
Thank you.